in running businesses in Bangladesh, covering regulatory approvals, permits, and licenses. His extensive academic background, including a chartered secretary qualification and an LLM, adds to his remarkable expertise.
Next, we have none other than Ms. Akshata Kulekar, the founder of Genesis Legal, known for her exceptional expertise in intellectual property rights and media and entertainment laws. She's a secured landmark judgment. She secured multiple landmark judgments and manages diverse trademark and copyright portfolios. Ms. Akshata's legal acumen extends to startup legal consultancy, providing tailored solutions to a wide range of clients. As a thought leader, she actively shares her insights at education institutions and industry events, making her a sought after authority in IPR, media, and entertainment as startup advisor.
We also have Dr. Madhvi, a dynamic professional with a diverse career. She has worked with prominent organizations like Cadbury India, Jetted Yellow Pages, and MSource India Private Limited. Currently, she serves as a professor and program coordinator at CMS Business School, Jain University. Dr. Madhvi is a prolific researcher and academician, having presented numerous research papers at prestigious conferences, earning her 6 Best Paper Awards. Her expertise spans various domains, making her a valuable resource in research and business decision making.
Next up, we have none other than Dr. Soni Vijayan, a seasoned professor of law at Manipal University, Jaipur. With over a decade of teaching and research experience, she is well versed in a variety of legal subjects, including maritime law, corporate governance, and intellectual property rights. Dr. Soni's academic journey includes impressive qualifications such as an LLB, ML, and PhD, and her research expertise lies in admiralty and maritime laws, intellectual property rights, and commercial and corporate. She is not only a dedicated academic, but also a consultant and supervisor, contributing significantly to the field.
Our next speaker is Dr. G.R. Raghavendra, a retired civil servant with extensive experience in various government departments. He served as Joint Secretary in the Department of Justice, Ministry of Law and Justice, with a focus on policy reforms and the ease of doing business. Dr. Raghavendra is an intellectual property law expert who played a crucial role in the amendments to the Copyright Act and copyright rules. He is a prolific contributor to WIPO treaties and has lectured on copyrights and related rights at national and international seminars and workshops. His diverse academic background, including a PhD in IPRs, adds depth to his expertise.
Lastly, we welcome Mr. Henry Tobachikwu Ibekwe, an ambitious legal practitioner with a core interest in startup and tech laws. He has practical experience in startup advisory, data protection, real estate, corporate, and commercial laws. Henry's passion for the startup ecosystem shines through as he currently works with two startups as a legal or compliance officer. Beyond his legal work, he enjoys adventure travel, playing the keyboard, and solving puzzles, obviously. Henry is an active member of the corporate governance community for Nigerian startups and the National Association of Property Lawyers of Nigeria. So, now let's begin the discussion. Before that, we would like to request all of you, including our fellow speakers for today and attendees, to kindly switch on the respective webcams. Would also like to inform all the attendees and participants in particular that anyone without the webcams on shall not be certified at the end of the conference. We would also like to inform you that the HR team is conducting calls in the chat box throughout the session. We encourage active participation from all attendees. Once again, thank you all for joining us today and giving us our valuable time and also contributing to your knowledge learning efforts. Now, let's begin the conversation by inviting our first speaker for the day, Mr. Tuhim, to commence his speech and share his insights.
Thank you everyone. Thank you SK Associate and groups for inviting me here. Uh, all well is ends well. This is the last day of this conference, and we all know that morning shows the day. I don't know what impact I could leave here, but I will try my best to leave some impact here. So I will not share any formal presentation, just I will describe the general impact of the intellectual property rights in the emergence of startups, like the pros and cons. So intellectual property rights are the actually bedrocks upon which startup builds their innovative foundations and navigate the waters of business competition. Here we explore how IP rights interactively weaved into the fabric of startups, shaping their emergence and growth in 10 significant ways. Number one, protection of innovation. IP rights shield the novel ideas, technologies, and creative works that form the nucleus of startups, assuring inventors that their creation are safeguarded. Number two, attracting investment. Robust IP portfolios can substantially boost a startup's valuation, attracting investors who are protected intellectual assets as well. Number three, diverse revenue streams. Startup leverage IP through licensing, franchising, or selling patents, creating revenues streaming beyond their core products or services. Competitive fortitude. IP rights erect formidable barriers, deterring rivals from replicating innovations and conferring a competitive edge. Market domination. By securing IP rights early, startup can establish themselves as market leaders, mitigating the risks of competitors overshadowing them. Risk mitigation. Proper IP management safeguards against legal disputes, reducing IP potential for costly litigation that could cripple a startup's resource. Brand identity. Trademarks and branding IP aid startups in establishing distinct brand identities and fostering customers' recognition and loyalty. Global expansion. IP protects extended across borders, facilitating the international expansion and safeguarding startups' intellectual assets worldwide. Catalyst for innovation. That's number nine. Knowing that their intellectual property is protected, startups are incentivized to invest in continuous research and development, fostering a culture of innovation. Strategic alliance IP. IP assets can be leveraged as valuable bargaining chip in negotiation with strategic partners, collaboration, or potential acquirers, enhancing a startup strategic position. So now I will actually describe the disadvantage of not having intellectual property rights in a startup business. Not having intellectual property rights in a startup business can pose several disadvantages, like vulnerability to copycats, like without IP protection, innovates idea and technologies are vulnerable to being copied by competitors, eroding a startup's unique market position. Limited attractiveness to investors. Investors often seek startups with protected IP as signifies a competitive advantage. Lacking this protection may deter potential funding. Inability to monetize the innovations. Startup may miss out on valuable revenue streams such as licensing their IP, which could have otherwise supported growth and sustainability. Risk of litigation. Startup might face legal battles if their inventions are used without permissions, leading to costly litigation and resource drain. Reduce market value. The absence of IP protection can diminish a startup's overall market value, impacting its ability to negotiate favorable partnership or acquisition. Weakened brand identity. With trademark protection, startups may be able to establish a strong brand identity, making it easier to build customer recognition and trust. Hinder international expansion. Expanding into global market becomes risky as there is no assurance that the intellectual assets will be protected internationally. In sum, the absence of intellectual property right in a startup business can leave it exposed to numerous risks and hinder its potential for growth and competitiveness. In conclusion, the interplay between startup and intellectual property right is underlined uh, from nourishing innovation to attracting investments and fortifying market position. IP rights are indispensable in the journey of startups from emergence to sustained growth. In addition to this information, I would like to mention that uh, in Dhaka, within just last 5 years, 35 IP law firm has been established. uh, can you imagine, within just 35 years, within just 5 years, 35 IP law firm just established to support the startup businesses and the other businesses IP rights. But before 5 years, there were only 6 to 7 IP law firms in Dhaka, only in Dhaka. So we all can assume that the importance of IP rights in the startup and the business realm, what it could be. So that's all about my presentation. If you have any questions, I would like to answer them. I will leave my email in the chat box. You can reach out to me. Thank you everyone for listening to me.
Mr. Tuin, I had a question for you. Since you are the only panelist on our in our conference from Bangladesh presenting your country today, what is the average time that an entrepreneur would need to secure a trademark in your nation?
Okay, it could be 7 to 1 year, 7 months to 1 year.
For
Depends
trademark?
on the complexity.
And the what is the tenure in the case of patents?
It could be within 3 months, but if it is in a complex situation, then it depends actually.
Okay. And as we have seen in cases of multiple public listed companies, especially whenever they collaborate with a foreign entity, we do require the approval of relevant ministry, most probably the Ministry of External Affairs, to be involved in such cases. So, what would be the average duration if any public listed entity wishes to collaborate with a foreign entity? What would be the average duration of approval from the ministry in Bangladesh?
15 to 30 days.
15 to 30 days.
Right.
That's quite good. Thank you.
Yeah.
Further,
Yeah,
I would
most
like
welcome.
to invite all the participants to put forth their questions, if any. You may simply unmute yourself and ask your question, or you may type your question in the chat box too for Mr. Turin to answer. Yeah. No questions today? Fine. I guess that's it. Anjali?
Yes. So thank you, Mr. Heen, for the insightful speech. As you said, please share your email address in the chat box, and if anyone in your audience has any questions or need further information, please do reach out to him. Now, I would like to invite Ms. Akshita to commence her speech.
Hello, everyone. A very good evening and a warm welcome to all of you. Personally, I thank SK Associates and Group for inviting me here to deliver this speech. I'll be sharing a presentation and I'll be going along with the presentation. Uh, do I have sharing rights?
Yes, you do.
Is my screen visible?
Not yet.
Okay.
The fourth button from the left, Akshata. The square icon with the upper headed cursor in it.
Yeah, I pressed that entirely.
Is the screen visible, Anjali?
Not
It's
yet.
not visible. You may want to try sharing it as share window, not tab.
Share window. Yeah. Now is it visible?
Not yet.
Do you see a small strip of message beneath the screen that says you're sharing screen?
Yes. Choose what to share, and that is what I'm choosing. And I have a message on my screen saying can't share your screen.
So you're still not sharing.
Uh,
Yeah. Could I share the presentation to you, and maybe you could share it from your end?
Yes, you can share it
Yeah.
with me.
All right, lovely.
sure.
I've shared it with you, Anjali.
Did you share it on my mail or WhatsApp?
On WhatsApp.
Okay, just a minute.
Till Anjali shares the screen, you may begin your speech, Akshata. If you're
Yeah.
ready.
So to introduce myself, this is Advocate Akshata Ankolekar. I am the founder of the firm Genesis Legal. We specialize into intellectual property laws, media laws, corporate laws, and data privacy. I'm here today to give you a little bit of an insight into the ever-changing and ever-growing world of intellectual property rights and how it could help startups. So, just a little request, let's make it an interactive session. Pop your questions in the chat box as and when you have any. So, Anjali, could you share the screen?
Yes, just a
Yeah,
minute.
yeah. So until the presentation is shared, I'll just give you a little bit of tidbits into intellectual property. So did you know that there was a time when 80% of a company's asset were physical in nature, whereas the remaining 20% assets were intangible ones. However, today the ratio has completely been inversed. 80% of companies' assets are now intangible assets, and intellectual property makes majority of those assets. And now, majority of them account only and only for intellectual property rights. This can easily be seen from data which proves how much a brand is valuated. Yes, thank you so much, Anjali. So a little bit of introduction again. Once again, I have 8 years of experience in intellectual property rights. I've handled matters in infringements in the Bombay High Court and the Delhi High Court as well. We have several landmark judgments on our in our name. In the past, we've handled clients ranging from GoAir, Jain Irrigations, BMW, Samsonite, Spec, and we've also worked with several celebrities in the media sphere, ranging from Chitra Jagdeep Singh, Hrithik Roshan, Sonakshi Sinha, and Priyanka Chopra. Next. Yeah. So my law firm's name is Genesis Legal. We are based in the financial hub of India, that is Mumbai. And we encourage the startup wave completely, and we believe in litigation as our last resort. Next. These are our specializations: intellectual property, everything dealing with intellectual property, from filings to registrations to litigations, media and entertainment, and data privacy as well. Next. Yeah. So today, intellectual property is known as the oil of the century. Look at the richest men in 100 years ago. They all made their money extracting natural resources or moving them around. Today, all of the richest men have made their money out of intellectual property. So this is the oil of this century. Now, what is intellectual property exactly? Intellectual property is it's just property which is translated into a tangible form. It's a reward for creative exercise of the human mind, labor, or a monetary investment. So when we use the word property, is it similar to physical property, and if yes, then how? Yes, it is very similar to physical property in a way that it can be owned and exploited in a very similar way. It can be bought, sold, mortgaged, or even licensed, as real property can be licensed. Next. Now, the benefits of protecting your intellectual property. Why should a startup or an MSME or a corporate for that matter protect intellectual property? Firstly, it provides businesses a competitive edge in the market. Having a brand to yourself is a huge advantage. Creates a loyal consumer base in the market. It establishes credibility and reputation in the market. It allows the startups to compete in the market with their competitors. It increases a company's valuation in the market. It also protects the companies against third-party infringements. In a way, no third party can then copy your brand and register them for themselves. It gives a company exclusive rights for the exploitation of their intellectual property. However, what happens if we ignore protecting intellectual property? Next slide, please. It gives rise to knockoffs, that is counterfeit products. Let me tell you, India is now slowly and slowly diversing from a reputation that it had gotten a long time ago, knowing as a counterfeit land, because we used to, really manufacture a lot of counterfeit products. So this, non-protecting intellectual property gives rise to this. It gives rise to brand dilution. Market share of a company is affected. The brand loyalty and the credibility of a brand takes a beating. Reputation, trust earned in the market through a loyal consumer base is at risk. We put so much time, money, and effort into creating a loyal consumer base. Imagine if it is just taken away from you in 1 second, when your brand is not your brand any longer. Hurts, right? So a competitor may go ahead and register your intellectual property and further prevent you also from using your own intellectual property, which will give rise to immeasurable monetary losses. So now that we realize that it's pertinent to protect your intellectual property, what are the kinds of intellectual property that are available for protection? Now, this question is the most important question that is to be answered. Most startups, most companies or corporates, can't figure out which intellectual property is their best pick. Next slide, please. This is the problem, identifying intellectual property. Next slide, please. So there are several kinds of intellectual property at hand. We have trademarks, we have copyrights, we have patents, we have designs, we have geographical indications and trade secrets as well. I'll dwell deeper into every intellectual property for you to understand how to identify which intellectual property is suited best for you. Next slide, please. Now take this one picture. Please focus on this picture. In one picture, there's one product used, that is a Dyson vacuum cleaner. Can you please tell me what kind of intellectual property is there in this one picture? Can I get any responses in the chat box? Anybody? Absolutely right, Dr. Madhvi. Patents. Thank you for responding. Anybody else? All right, moving ahead. The brand Dyson is a registered trademark. And as Dr. Madhvi rightly pointed out, the technology in a Dyson vacuum cleaner is patented. The design of the vacuum cleaner, which is a unique design in itself, right? The design is protected via a design registration. And the industrial drawing of the product. Before the product is born, there is an industrial drawing of the product that can be protected through copyright. And even this photo itself is a copyright protection material. So here we have one product and so much intellectual property involved in just one product. Funny, isn't it? Intriguing also, right? So yes, let's move ahead. Next, let's tackle the first kind, that is trademarks. What exactly are trademarks? As you see on the screen, you might recognize all of these logos on screen. Do you? Yes, they're all extremely popular brands and their artistic representations. However, one must know that the trademarks aren't just names and their logos. A brand can be represented in so many more ways than just the name or a logo. Can you guess the other kinds of the trademarks? Next slide, please. Trademarks can be so many things: word marks, logos, even your taglines or slogans can be trademarks. Do you remember any? I am loving it. Just do it. All of these taglines, they bring a certain brand to your mind, don't they? You associate a certain brand with a tagline. That exactly is a trademark. Sounds, the Britannia tune, the McDonald's tune, or the SL World tune, all of them remind you of a particular brand, isn't it? So that also is a trademark. Shape marks, color marks, device marks, numbers, so many things. All of them are trademarks. Next. Here we have a very, very known case. Everybody knows them. Samsung versus Apple. Big giants in the technological industry, right? Telecom industry. And yet they are at loggerheads with each other. So because they've copied a design. Apple was awarded over 1 billion in damages through the case but it has also went through multiple appeals. Next. Adidas versus Payless shoes. Do you see the pictures on the slide? Very, very similar pictures. It can be very easy for, for a customer to get confused. Yes, that likelihood of confusion in the market results in Adidas winning and being awarded $305 million in damages. Next. Louboutin versus Yves Saint Laurent. These things. Do you see the red sole in the picture that the both the stilettos have? That red sole is protected via Louboutin as their trademark, and because Yves Saint Laurent was copying the trademark, Louboutin's trademark was protected and upheld. Next, coming to copyrights. Next. Yes. So we all relate to this in some kind of way, right? We see so many things all around us. It applies to all the things which are literary or artistic in nature. Audio recordings, songs, videos, films, books, any kind of literatures, dramas, choreographies, graphics, everything that you see around. Now even apps, source codes, sketches, sculptures, architecture plans, everything can be copyright protected. Next. These are certain case laws which are extremely popular in the realm of copyright law. A little bit to know about the copyright law, there are certain things very peculiar to just copyright law. It doesn't protect the idea in itself. The said idea needs to be expressed in some way or the other for it to be an original idea. Okay. In the same way, Napster lost and it had to shut down its services, leading to significant changes in how music is distributed online. Now, this idea in itself wasn't original, right? It was copied it was copied by Napster through A&M Records. So that is why Napster lost. Next. A very, very popular show. Everybody knows and have heard of it, right? Kaun Banega Karodpati. Everybody must have even seen it at some point in their lives. Here, Star India sued Leo Burnett for creating an advertisement that was even similar to the format of the popular show Kaun Banega Karodpati. Bombay High Court has ruled in favor of Star India and has protected Kaun Banega Karodpati. Next. Coming to designs. Designs are basically the shape of the product or the packaging. We have an example of Coca-Cola bottle. Here it has evolved since 1899. You must have observed so many, changes in the bottle over time. None of the cola drinks have a similar packaging. if you must have observed. Every cola bottle has a different packaging. Now, why exactly is that? They all have the same function, right? To store the what do you say, the liquid in the bottle, to store your cold drink in the bottle, yet they have different shapes. It is only and only because the design registration of the product, it the design registration is only and only concerned with the aesthetic look that it gives a product. Next, here, compare the two shoes, extremely similar in their design, extremely similar in the way it looks, only and only the aesthetic element very similar to each other. Next, again a very popular case, Whirlpool India versus Videocon Industries. Everybody must have heard of this. The two they have copied the design. So the Delhi High Court had granted an injunction in favor of Whirlpool, restraining Videocon to manufacturing similar designs. Next, Ayush, I will definitely answer your question. Coming to your question right back, let me just finish this one more case study and I'll delve right into your question. Colgate versus Anchor Health. Do you see the packaging of the product, Colgate and Anchor? Yes, very similar. Extremely easy for a consumer to get confused in two of the packaging, right? So because of this confusion, Delhi High Court has ruled in favor of Colgate, again stating that the design was original and deserved the protection that it got. And Anchor was, had an injunction against it and refused to use the same packaging. Next. All right. So, by the way, different designs can lead to lack in consumer preferences. Are you asking me if they can, Ayush? Okay, so consumers are extremely open to designs, to be honest with you. Bringing newer and newer designs in the market can, you also can establish your identity, your brand identity with a very different design in the market. You not necessarily that you compete with a similar product with a similar packaging, which, to a product that is already existing in the market. You can always build your own brand identity. And I think consumers are extremely open to newer designs that are coming in the market if it does not affect the applicability or the functioning of the product. Uh, Moving on, have I answered your question, Ayush? Okay. Moving on to patent. Now, what can be patented? So there are so many things can be patented. A trade, any processes, any machinery, any manufactured article that has an inventive process or a novelty value in it can be patented. Any composition of matter, anything that has invention can be patented. Next. However, you need to have three criteria if you want your patent to succeed, to get it registered. First is novelty, second is non-obviousness, and third is the industrial applicability of your patent. It must be applicable in the, like, it must have some industrial use. Next. A very unique case again here, Bayer Corporation versus Union of India and others. We see a lot of these patent cases coming up in the pharmaceutical industries, because they have very similar compositions, just the brand names are very different. You must use very similar products, Dolo, Calpol, Crocin, all of them basically are all paracetamol, right? However, some pharmaceutical companies have different compositions which they themselves invent, and they want protection over that. However, high courts sometimes don't they rule against them because the compositions are basically generic in nature, and which has to be open to the public, and other companies also should be able to manufacture them because they are generic in nature, right? Here competition law comes into picture. However, we are not dwelling a lot into competition law right now, so we'll touch upon that if at all you have any questions with regard to that. Next. The last form of intellectual property, confidential information or trade secrets. Now, do you see the pictures on screen? There is a McDonald's, there is Coca-Cola, there's KFC, and there's Listerine. Does anybody know any recipe or anything with regard to any of these products? Anyone? Okay, I'll take that silence as a no. It is only and only because all of these are protected via confidential information and trade secrets. Next. Yeah, coming to the main point, monetizing your intellectual property. How should you be able to monetize, make money out of the assets that you found over time in your company, in your startup? Firstly, having a registered right will help you secure investments for your business whilst increasing the valuation of your company manifold. Secondly, you can branch out, create franchisees for your brand. You know, your one brand can be everywhere. Look at McDonald's, look at Domino's, one brand everywhere. Licensing your IP can also be a secondary revenue generation, a generator for your company. So all of these, there are tactics to monetize your intellectual property. Next. Yeah, so there are so many benefits that even governments offer for startups for them to, you know, be extremely, what do you say, stringent when it comes to intellectual property. There is a scheme named Startups Intellectual Property Protection, that is SIPP. This scheme is designed to nurture startups and assist them in protecting the intellectual property that they have. They have a 50% flat discount when it comes to registration of trademarks and up to 80% discounts when it comes to patents. You all must know patents as compared to trademarks are extremely expensive, right? So 80% rebate there is a great help to startups when they start off. Next. Here, this scheme facilitates also quick filing and quick disposal of intellectual property applications. In India, right now, we are facing a very major shortage when it comes to, officers at the registry level. So here, what they do is trademarks generally take over 8 to 12 months with regard to registration, right? So here, if you're a startup and if you go through this scheme, you might get the certificate earlier also. Same is true with regard to patents. Also, there are just two requisites that one must consider while taking the benefit of this scheme. Firstly, the entity must be registered as a startup. You must have a startup certificate. Secondly, the entity must enlist the help of a facilitator. Only then can you use this scheme. Next. Yeah, so all these incentives for new startups, right? There are so many things. No inspection for the first 3 years, self certification compliance, no income tax on profits for the first 3 years. uh, you know uh, Startup India is doing a lot to accelerate startups in India. There is 80% rebate, like I said, on the patent filing fee. Then bankruptcy bill, 2015, 90 days to exit business. So many things that can help startups in multiple ways. Next. There are also a few benefits that government gives not only to startups but also to MSMEs. That is a scheme named Make in India. Government is now encouraging people to, start entrepreneurship in India via the Make in India scheme. Next. Here, if anybody has any questions, we come to the end of our presentation. We provide free consultation to startups, also to MSMEs, also looking to safeguard their intellectual property. If you have any questions with regard to anything, please let us know. Here, that's it. Thank you so much.
Akshita, I had a question for you. Now, from the perspective of regular business owners rather than startup founders, since we also have multiple entrepreneurs in this meeting who
Right.
obviously will be owning regular businesses, very regular, as simple as a mall or as simple as a law firm, as you and me. So, in such cases, can they get a trademark for their company names if
Of
they
course,
are into regular businesses?
of course. Everybody can and must get a trademark for your company name. Your company name is your little brainchild, isn't it? You get life insurance for your children. Your trademark is a life insurance for your brainchild there. So always get a trademark for your company name.
That's great.
Yeah.
And as for law firms, what do you have in your mind? Like for law firms, founders in specific, in terms of intellectual property rights, any advice?
For law firms,
Yeah.
Most law firms don't get their names protected themselves. So uh, I think I urge law firms also, because their name is unique in itself, right? So they also must get to create a brand. You have to have a brand. You have to protect a brand to create a lasting legacy. So that is what I would say. Yeah.
Oh, this is something you took from my
And I
heart.
also would urge law firms to help facilitate startups as much, lower their
Exactly.
fees, and work on subsidized rates themselves, like we do at our law firm. So we are also contributing a little bit.
Any questions from the audience? You may simply unmute yourself and put forth your questions, Rakshita.
Yeah. I read some on the chat box. Could I go through them myself?
That's Paul, to be
Yeah. All
precise.
right. So thank you so much, Tuheen, for your appreciation. Appreciate it. Rima, invention means new product having invented step capable of industrial application. Aniva. Okay, it's a MCQ I see on your and the chat box.
This opinion poll.
Your answer must be C. It's a new product or a process. It can be a manufacturing process also, and it can be a new product also that can be protected through a patent. Yeah. Okay. Am I right, Rima?
Please.
Okay, all right. So, if we come at the end, I'd like to thank Anjali so much, and extremely sorry again for the little bit of disruption at the very beginning. Thank you so much, Anjali, for helping me, get the presentation on track. Yeah,
No issues.
yeah,
Thank you, Akshita, for your
No
enlightening
issues.
speech and sharing your valuable insights with us today. Please do share your email address in the chat box for any queries that our audience might have or they might have the wish to
most
reach out
definitely.
to you personally.
Most definitely.
Now,
Thank you.
moving ahead, I would like to invite Dr. Madhavi to commence her speech.
Uh, Good evening, everyone. I have to say, it's a delightful continuation for me from where Advocate Akshita has spoken about. You have covered all the fundamentals so beautifully. Thank you so much for that. As a professor, and I have the opportunity of being a consultant in the MSME segment. In the last slide, when you said you would like to offer pro bono services, I was like, there might be a couple of startups that I know who could use this. So I'll probably forward your contact information to them, and they'll probably reach out to you on that. Thank you so much for that, Akshita. Um, since one of my fundamental roles is the role of a professor in a B school, a pretty acclaimed B school here in Bangalore. So we tried to bring in an idea into just insight into the college where IPR had to receive a little bit of attention. And UGC has been appealing, also trying to command that higher educational institutions should become some kind of, a hub where IPR discussions begin. So a few years ago, we took this up very seriously. That's when the initiative started, and that's when I was the campus coordinator taking care of these matters, which pushed me into a lot of learning because this is one of the papers that I teach as a B school professor, and probably that was the reason I took this up as well. And based on that, trying to take this as a point to connect higher education and startups, especially for students. Right? This is the outline of my entire talk. I want to limit it to three specific thoughts. How do you bring IPR discussions to the forefront in higher education? Are startups and incubation centers aware? And why would students want to be a part of it? Is there a pull strategy that can be applied? So this was one of the ideas that I designed and simulated across CMS Business School, where we planned a session by first collecting problem statements from a valid source that the university office facilitated for us. So we had this hundreds and hundreds of problem statements taken right from the field of IPR. When I requested more information on what these problem statements stand for, I received input from the university office that these are the ideas that many companies would have applied for IPR, then for some reason, due to some amount of incompletion or lack of the requisite norms or parameters, the idea was not accepted for IPR processing. So a large number of statements were from that arena, and similar thoughts were added, and we had a whole big bunch of these statements that we were able to put our hands on. And then we started doing these sessions. So we were wondering what will we do in this session, right? So very briefly, this is what happened. It opened up the talk. We didn't set any targets. We said, you know what? Just come. Just come to the conference hall. We made it as a designed program. A set of people were identified, emails were sent, signed by the dean telling you will be present here. So we wanted to bring in diversity. In how many counts, on how many counts can I bring in diversity for an event such as this? So we curated the names across departments, telling, okay, we'll bring these many people from each of the departments. That will bring in separate thoughts because their specializations are different. Then we said, how about we go beyond the B school and consult the design school, or consult the School of Humanities, or consult the School of sciences, right? So we sent out the invitation to them, appealing them to join as well. And at the same time, we felt you should have gender diversity. So bring in male professors and female professors. We should have age diversity, bring in students and professors. And we call this as a hierarchy-free environment. We removed labels and we said, we are here to just talk. There are no targets. There are no certificates to chase, and there's nothing that's getting recorded, and nobody will be tested at the end of this. There's no exam at the end of this, right? We said, let's begin this talk and listen to each other by distributing these problem statements randomly and also keeping a stack of them. Additionally, should somebody say, the couple of ideas that you've given me, I'm not very happy with that. And because I come from a core finance background and you've given me a technology idea, which I'm not able to read and decode, we also stacked up additional ideas in the same conference room and allowed people to move around the room. And we closed the door for that 1.5 hours. And then we repeated this process. Every month, or sometimes a little less than a month, we tried having this. And every time we had a new set of people come in and do this. And at the end, we said, you can continue discussing. It's a very informal task. You don't have to go back and report anywhere. This is not one of your official tasks. And time was set aside for this so that people are not burdened with overlapping tasks. So what was the result of all this? In less than 1 year, we had 10 accepted patent applications by the Patents Office in Government of India, which are now getting processed, and we are looking forward to receiving those patents. So this became a huge encouraging factor, and people started thinking it's okay to say that I have an idea. And people would come up to me sometimes, not always, and say, look, ma'am, I have an idea, but I don't know if this is worthy enough to be patented. I don't know if this is novel enough. I don't know if this will have an industrial application. So keeping that in mind, when they said, I told them, see, I will assure you discretion. I will not discuss this with anybody. And I will listen to you, but I may not be the one to give you all the answers because I'm not really a patents advocate. In more number of cases than not, these ideas had some amount of novelty. So anytime during the discussion, one of us felt that, this sounds new. I haven't heard about this in the market. And we said, let's curate a few sources and resources and see how we can check. So we took the idea, just in the mind, and we started searching for similar ideas on the grand database that's designed by Google on patents.google.com. In the process, we realized it's very important to not write your idea because Google will capture that. Every search input is captured by Google. So people quickly realized that and they stopped writing what their idea is. Rather, they use the generic words associated with their novel idea and they started searching for what's available. And this turned out to be a useful exercise because uh, patents.google.com gives you an elaborate list of patents which have been registered in the USA. It allows you to go through the entire document. It allows you to understand what is typically called as techno legal writing, which was completely lost upon people in higher education. I have to place it on record and confess because students were intrigued, very happy, but then they were like, how am I supposed to navigate through this? Right? I'm very happy to say within the first 1 year, we had 10 applications by faculty members which got accepted, three by students which got accepted. We did go through one IP advocacy where they again did the patentability research and they approved that yes, this has novelty and we should be driving this ahead. So many higher educational institutions today are honestly battling with this question, telling, "Hey, I want to get into this space," and trust me, if you look at students and give them this opportunity, they will have a puzzling look on their face, but they will try and do something very useful. It's just that somebody needs to stand there and drive it deliberately. Now, are startups and incubation centers aware? I would say yes and no, because I do go to incubation center related programs, related events. I sit with startups for strategy related consulting work. I've done multiple projects. And I noticed that at some point, sooner than later, the entrepreneurs realize that they need to work on the IP part of the entire thing. But again, more often than not, they take more time to actually address that, right? So, what stops them from doing that, according to my observation, participation, and learnings as a person in this space, is they begin identifying what's actually missing a little late, or it takes time for people to get that clarity, right? So, how do you strengthen the weak link? I feel there's a huge gap between the startup world and the world of higher education, which ideally should not exist. If we start building this gap one step at a time, I think you can strengthen the weak links. So we wanted to initiate a dialogue. We started inviting a few startup entrepreneurs to come for guest lectures, which has paid off in certain ways in terms of creating awareness. And another idea that we are working on is to have a closed door conference with a selected number of startups and creating a platform for them to dialogue, bring open a dialogue upon these matters, and then connect that with students who aspire to become entrepreneurs. At the same time, it'll help them identify some common touch points and address some pain points. Um, Now, some enduring resources as part of this is, again, like I said, when we began with these initiative a few years ago, we didn't know where to begin, and I noticed Government of India has released a FAQ document in 2020 at the height of pandemic. This nice PDF was released, and that gives you all the fundamentals. It helps you understand just all the basics in one document. LinkedIn Learning has courses that give you a lot of real insights and amazing examples, right? There are a lot of IPR seminars and workshops that are happening today more than before since the world went online during COVID. Just last month, I think Money Control reported this, telling India will be able to issue 1 lakh patents in 1 year in the next 18 months. This is in support of what Advocate Akshita was talking, that we have a huge dearth of experts who can curate and approve a certain application, whether it deserves to be patented or not, right? So this bandwidth and infrastructural deficiency is now being addressed at a national level, which is a huge welcome initiative and a huge thumbs up from a lot of stakeholders. EICTE began an initiative for any of us who are not aware of what it stands for. I think it's All India Council for Technical Education, where B schools, engineering schools, etc., fall under its approval and guidance for a large number of matters. They designed a new initiative just about a year ago, and they said we will allow 10 patent applications to be sent across by each registered higher educational institution under AICTE, and we will process all of them free of cost. This was another initiative to support and encourage higher educational institutions in terms of IPR discussions. Why would students want to be a part of it? Can we really have a pull strategy? Because at the end of the day, we all know students are the bigger um, in number in terms of the stakeholders, right? So I'm just putting across a few points based on my learning in these matters. One, can you integrate this into their learning regardless of their discipline? IPR discussion needs to step in, whether you're an engineering student or a student of design or a B school student. There is some opportunity somewhere where IPR has to be addressed as part of the syllabi, as part of internal assessment activities, as part of group projects. Now, today there are universities trying to bring in multidisciplinary group projects where students across departments will be mandated and teams are formed and they have to come out with projects. In such cases, now these are all, again, not very easy initiatives. There will be resistance, but eventually, I think all the stakeholders will learn to see the value, right? So these are some ways of incentivizing it, but incentivizing doesn't stop by compelling students to add this into their curriculum matrix and marks card. Can you add this into the incubation center? Can you add this into a new business plan that they propose? Can you add awards? Can you provide recognition? Can you provide monetary incentives? Can you mix and match all of these things in an acceptable way? So there are many opportunities that are getting created as far as IPR is concerned in higher education. And of course, there has to be somebody who keeps nurturing this encouraging environment. And in my experience, like I said, the first 1 year, I took it up so aggressively that we had 13 applications which were valid just from one institution of the university. And I think the closing thought on that note is don't look for the solution until you know you have the right question in hand. Thank you so much for having me here. Those were a few of my thoughts, and I close it right here. Thank you all.
Dr. Madhavi, your speech was quite enthralling, though I have a very practical, on the ground question for you. Just one. As far as your profile goes, you have 16 years of experience into the education sector. So, obviously, as far as the experiences, can you just state a number of students, an average batch of 100 students, who would be more interested into entrepreneurship than average employee?
That's a very interesting question. See, there are too many inhibitions when it comes to being an entrepreneur, right? So, in fact, we have a department of entrepreneurship, and right now that's not the largest department, right? We have less than 50 students in that. When you look at something like core finance or core marketing, you have hundreds and hundreds of students literally jumping, trying to grab such specializations. I think it's going to take a little more time before we see those numbers grow because everybody knows once you complete higher education, many of us are in a situation where you have to become independent financially and you need to know how you can put food on the table. And you need a bit of gestation period if you choose entrepreneurship before you can show some positive revenue stream for your family, right? You need that backup. So I feel that's one of the huge barriers which is stopping. Otherwise, given a chance, I think if there's enough encouragement and if this inhibition is removed, there'll be larger number of students choosing that.
However, what would be the average number you state, like in 100? How many would be
That's
turning?
why I gave you the actual B school numbers where I work. Our number of enrollments for entrepreneurship is less than 50 right now, but for the other, see, ours is a B school of 2,000 plus students right now. Okay. Although the specializations are yet to be chosen by the first semester students, we are still in the odd semester, right? If I look at the final year students, we have less than 50 students in entrepreneurship and new venture vertical, but we have at least 300 to 400 in rest of the verticals.
That's a good practice.
Yes.
Yeah. Okay. So I would like to further invite the audience to put forth the questions to Dr. Madhav, if any. Please, you may type it or you may simply unmute yourself and put a question across. Even the fellow speakers are permitted. cross question each other.
I think there's an observation that Akshata made. Yeah, it's a brave decision for students, but definitely a rewarding one. Yeah. You're going to need a lot of support from the family more than anything, I think. Yeah.
So again, no pain, no gain.
Okay. No worries.
Okay. So I think that's it, Anjali. You may continue.
All right. Thank you, Dr. Madhvi. As we don't have any questions, so please share your email address in the chat box. And if anyone in your audience would like to connect with you in future, you can go ahead and connect with her with the email address. Now, our next speaker is Dr. Soni Vijayan. She has not joined us today, but she has sent her recorded speech to us. Let me play for you. Just a minute.
Excuse me, Anjali, the audio isn't audible. If you could just look into it once.
Is it audible now?
If you could just play it.
Is it audible?
Not exactly. Srishti, am I audible?
Yes, you're audible.
Is the audio audible in the video?
No, no, no. Do you want me to play it? Like I can play it from here, from my end, if you want.
Uh, Anjali, would that be preferable? Yeah, fine then.
Yes, Sakshi, you can
Okay.
play it from your end.
Fine. Share your screen, please.
Mm, mm, mm.
Good evening, all of you. Myself, Dr. Soni Vijayan. I'm joining from the School of Law, Manipal University, Jaipur.
Is it
I'm a faculty
audible?
member here. I'm professor dealing with the
Yeah.
subjects intellectual property rights and commercial laws, and also admiralty and maritime laws. These are my areas of academic and research interest. And I'm also a PhD guide and research supervisor here. So I'm very happy to speak to you, all of you today. And at the outset, let me extend my humble thanks to SK Associates for providing me this opportunity to interact with all of you. So it's such a wonderful topic, isn't it? The impact of
The screen wasn't moving, if I'm right. Anyone?
I think she has left the
Okay, she'll rejoin. No issues.
meeting. Let me check from my end.
Just a minute. Hmm.
Is it fine now?
Yeah, the presentation visible. You may start playing once.
Okay.
The audio isn't audible in general. I think we can wait for a second till Shrishti joins. Uh, Fine. Shrishti is in.
Yeah, just a minute. Wait.
Yeah, sure.
Share this. Is my screen visible?
Yeah, it's visible. Select the
Yes, it's
presentation.
visible.
Sure. Now it's completely visible. The presentation isn't audible to me. Is it audible, Anjali?
No, it's not.
No, it's not.
Shrishti, if you could just do
This is the
something about the
maximum.
audio. Last time
This
it
is the
was working
maximum
out.
audio we can.
I'm guessing it
Other
has
messages are.
something to do with she sharing the audio.
Okay.
No,
Mm,
no, I'm sharing the presentation, but
Fine,
this is the
Shrishti.
maximum
Let's do
audio
a
we
thing.
can.
Just work out on the technical details for 5 minutes. Till then, Anjali, I think you can call the next speaker.
Okay.
Fine, Anjali. For the moving ahead, we would like to invite Mr. Henry Tobachukwu Ibikwe
Sure.
to commence his speech and share his valuable insights with us. I hope I'm audible, Henry. Sure, you may begin, Henry.
Hello, can you hear me? Okay. Um, Thank you so much for inviting me. I am in a noisy place, but okay, I think it's better here. I think it's better here. All right. Good evening, everybody. Good evening. Everybody can hear me, right?
Yes, we can hear you,
If
Mr.
you can
Henry.
hear me, just type something in the comment box. Okay. All right. Thank you very much. I just want to share my insights on the impact of intellectual property rights on startups. So I earlier today I was researching um, on the topic. I've been researching, but I was just checking through some things online, and I saw a report, today's report, a report dated today, 17th of October, 2023, by the European Patent Office and the European Union Intellectual Property Office. They said that startups with IP that have registered IP are 10 times, 10.2 times more likely to raise funds than startups who don't have IP, sorry, who don't have IP. And so that goes a long way to show how intellectual property impacts startups, intellectual property right impacts startups. And so my focus on today's speech is going to be on the benefits of intellectual property to startups, and then challenges that startups face in getting their IP registered, in securing their intellectual property rights, and then the solutions to make things easier for startups. First off, I think pretty much everybody knows that securing your IP is the smart thing to do, is the best thing to do. It's wise to secure your startup, to secure your IP, secure your trademark, your copyright, your trade secrets, and every other thing like that. But a lot of people don't have a commercialization strategy. Now, for instance, a lot of people don't know how exactly to make money from their startup, from their IP. People go on to register their trademark, people register their copyright, but it's the duty of experts in the field to give you a strategy for commercialization, a strategy that will make sure that you get money from securing your IP. And one of those benefits, the one I mentioned earlier, it helps you raise more funds. It helps you. It helps you uh, seem seem as a startup with more potential in the eyes of investors, because investors will will see you as innovative. Now, one of the key features of a startup is that it brings innovative solutions. And so if a startup is bringing innovative solutions, it means that it has to protect its innovation in order to secure its place as an innovative solution provider. You cannot be offering innovative solutions and then another person is offering the innovative solution and another person is offering it. And so there are five of you offering innovative solutions. It's no longer innovative. And so the smart thing to do is to secure your IP. Now, one of the challenges that startups face, I'll use Nigeria as an example. Let me give you a brief background of business in Nigeria. Before you can, and it's like that in every country, but in Nigeria, before you can legally do business, whether as a sole proprietor or as a limited liability company, now the body that registers businesses is different from the body that registers IP. Uh, and so I've seen a startup that went to go and register a trademark. The name of the trademark is the okay. Let me not disclose the name. You went to go and register a trademark, and when they came to the Corporate Affairs Commission, the Corporate Affairs Commission is the body that is in charge of registering businesses. And so when they come to the Corporate Affairs Commission to register the business, they find out that it's they they discover that there's already that name registered with the CAC, but they have the trademark, and another company has the CAC, the registration, the legal registration, and so they can. They're the only ones that have the rights to do business. To use the name as a trademark, but another company has gone ahead to register the business, and that gives them right to do business under that name. And so the struggle of having to file lawsuits, to protest against violations and all of that is going it's when you start calculating the years, it will take you maybe like one year or 2 years to conclude such lawsuits. And so it becomes a very, very key challenge that needs urgent solution. So startups or company or countries need to streamline their registration processes, so much so that IP registrations doesn't conflict with name registrations, because there are different companies that do that. And so the next thing I'm going to talk about is the costs of IP registrations. In Nigeria, it can take as much as 2 years for you to get your trademark certificate, the original trademark certificate. And that process costs sometimes up to $100. $100 is big money in Nigeria. $100 or thereabouts. And so a startup, everybody knows that startups are not financially buoyant, or they don't have the funds. They don't have the funds to spend on filing for patents, on those registrations. But when these registrations are expensive, most of them would like to go for the cheaper options, which ends up to their own detriment in the future. And
Thank you, Mr. Henry Tobachikuwa, for your insightful speech and sharing your valuable knowledge with us. Please do share your email address in the chat box. If anyone in our audience has any questions or needs further info, you may reach out to directly. Thank you. Further moving ahead, I would like to request Ms. Trishti Singh to share her screen and help us go through the recordings of Dr. Soni Vijayan's speech. I hope I'm audible, Trishti.
Yeah. You're audible.
Sure.
But the thing is that only the audio will be heard.
Sure. That will be fine.
Is it fine with that?
Yeah, we are fine. Let's just play.
Good evening, all of you. Myself, Dr. Soni Vijayan. I'm joining from School of Law, Manipal University, Jaipur. I'm a faculty member here. I'm professor dealing with the subjects intellectual property rights and commercial laws, and also admiralty and maritime laws. These are my areas of academic and research interest. And I'm also a PhD guide and research supervisor here. So I'm very happy to speak to you, all of you today. And at the outset, let me extend my humble thanks to SK Associates for providing me this opportunity to interact with all of you. So it's such a wonderful topic, isn't it? The impact of IPR on startups. So I was quite, confused about what to speak today, what to interact with you today, and I thought I will speak about trade secrets and startups. Because in India, we don't have a specific legislation for protection of trade secrets. So a lot of issues are there. So maybe if I can provide you with some basic information in the time slot allotted to me, I will be very happy. So the topic for discussion today is trade secrets and startups, a legal dilemma. So those who are, beginners or who doesn't have much information about trade secrets, for them I would like to explain that trade secret is actually a type of intellectual property. What makes trade secrets stand apart from other types of intellectual property is the cardinal or the fundamental principle upon which all other types of intellectual property rests is disclosure. But trade secret depends on secrecy. So two contradicting aspects. Other IPRs like patents, trademarks, it rests upon the principle of disclosure, whereas Trade secret depends upon the cardinal principle of secret information which needs protection. So obviously, as the name suggests, it is a secret which requires a reasonable protection in law, and it has some value economic from an economic perspective because of its secrecy. So the information in trade secret remains a secret, which is very important. So coming on to startups, how they are benefited from trade secrets is because as a new business firm or a startup, I can say the existence itself depends upon innovation, innovative strategies, business ideas, concepts that they develop, which they may not like to share with others, other entities, other firms, organizations, individuals, or other ecosystems from a competitive point of view. So there lies immense competition between firms. So whatever innovative business idea is there, how much innovative it is determines the very existence of a startup. So definitely, as an entrepreneur, a newly joined entrepreneur or proprietor or an owner of a startup, many of us would like to know about trade secrets and what sort of protection it has in law in India. What is the advantage of a trade secret? You know, um, the common belief is that trade secret actually hinders knowledge flow, or it is not for co-creation of projects or collaborations. But what exactly it does? Are secret information to be protected? Does it mean there should not be any collaboration between the firms, or there should not be any knowledge flow between individuals, persons, firms, entities? So, you know, it is actually a dilemma how far we should share with others, whether our business idea will be lifted up by others. So, all these are dilemmas for startups. Now, how important is the knowledge flow for innovation? Uh, of course, if we want to have some innovative business idea, there should be some exchange of information, expertise. Or if you sit in your cabin, keep everything secret and confidential, definitely the business will not grow. You have to, interact with others, exchange information, your expertise. This can be another individual, organization, firm, or any legal, artificial persons also. And this happens through collaborations, business collaborations. So business collaborations actually generate knowledge, uh, which germinates into innovation. So the very essence of innovation is, you can say, collaboration and knowledge flow. Okay, so a common myth about trade secret is that it hinders knowledge flow because of its secrecy nature. Like trade secret means a business idea or a secret which needs protection. So how can it encourage or facilitate knowledge flow? That is something, contradictory ideas, I would like to say. And there is also a myth that it negatively impacts innovation performance. Like people who support trade secret, who go for trade secret, actually don't want the dissemination of information. So nothing new happens. Whatever is with them, they keep it with them, and there is no knowledge sharing, no collaboration, and no innovation. So these are the myths about trade secret. But is there some way that we can encourage knowledge flow uh, or collaboration with respect to business ideas or novel ideas among entrepreneurs or startups? Is there any legal procedure? Will licensing, like in other intellectual property rights, is the correct way to do it, or is there any other way by which we can safely encourage knowledge flow and collaborations in terms of business secrets? So that is a relevant question. how far we can share information and by what means. So if you see the existing practice of startups or any new business entrepreneurship, uh, it progresses through different stages. That is, the initial stage is the idea where you have a new business concept or your secrets or confidential information. So with whomever you are entering into an agreement, the agreement has to happen at the beginning. So you're not ready to share the entire information to them. We call these as non-disclosure agreements in law. And this agreement happens much before the idea goes to the market. So it's a sort of commercial legal arrangement, you can say. So as a trust builds upon, you want to share the information, you would require to share the information to others. But in that stage also, we can understand that the trust is evolving gradually. So it is not necessary to share the entire information. Firms never do that. They will share only what is required. Absolutely necessary what information has to be shared, only that much the startups will share. So in the later stages of collaboration, sometimes these business discussions through initial legal arrangements, which contributes to trust. If it is successful, if successfully trust is built up, then they go for better collaborations. But sometimes there can be leakage of informations because the other party might treat your business information as their own information, which can damage your business. Or sometimes there can be differences of opinions between the firms or the startups. Like, you are ready to give your information, share your information to others, but they only receive and not sharing their information with you, their concepts with you. So it's just a one-sided business idea sharing only happening. So such complicated situations can give rise to legal disputes. But you have to understand, since there is no specific legislation for trade secret in India, such a dispute will be primarily based upon the legal contractual arrangement that exists between the startup and the other entity. That is for the contractual violations, basically, I would like to say. So when it comes to cases, you can say judicial approaches on trade secret protection, the observations of the court in Bombay Dyeing and Manufacturing Company Limited versus Meher Karan Singh is an important decision. Um, this is how court will treat whether the information shared between the parties is a trade secret or not. So that the court has to decide upon several factors, the most important factors being that how much of information is shared outside the business to the other party, how much of information the employees of the firm has about, how much of information they know about, what are the precautions taken by the holder of the trade secret to protect its secrecy. I mean, the owner of the firm, how much effort he has taken to protect it, how much money and effort he has spent, how much time and expenses or systems he had, created it within the organization to protect his business idea. All these matters a lot, whether to treat the information that was leaked as a trade secret or not. And from various judicial approaches, the ownership in trade secret, a firm can, develop by three methods. That sometimes it is created, sometimes it is acquired, and sometimes the business information is disseminated. Okay, so and significance of the protective measures adopted by the owner, like I told you, is also very important to determine the value of information that is leaked, that the court will consider. For example, you might have employed physical, technological, access control systems, or sometimes some contractual measures, legal measures also, like in what we discussed, like a non-disclosure agreement. So what all measures he has taken technical, non-technical measures, physical measures, which can be either in express terms or impliedly also, that is according to the facts and circumstances also matters a lot. So express measures can be like confidentiality agreements, NDA between vendors, employees, and implied methods can be like, these internal control systems inside the business organization to protect its trade secret, which are reasonable measures adopted by the proprietor. All these matters a lot in the eyes of law. And when there is a leakage of information as a trade secret, we call it as misappropriation of trade secret. So, like the guidelines provided by the court and the case law that we discussed, how much of information is there in the public domain, whether it is a secret or not, or what all reasonable steps taken to maintain its secrecy, whether it was an unauthorized information, and whether it was detrimental to the startup. All these matters in determining whether an actual misappropriation of a trade secret happens or
Excuse
not.
me, Mr. Shri.
Happens or
You
not.
could just
Accordingly, the
stop the
remedies
speech
will
for
lie
now.
in
With
the
pleasure.
court.
Sure. I would like to request you, Shishti, to share the video of the speech in all the conference groups and all related groups of the organization, so that all the participants can have access to the entire
Okay,
presentation.
okay, I'll share. I'll share it. I'll definitely
Sure.
share.
Thank you. So, firstly, I would like to thank Dr. Soni Vijayan for sharing the recording of her speech. Obviously, we do accept that we couldn't show the entire presentation in video format due to technical issues, but nonetheless, Mr. Singh from our team will be sharing the video in all the groups, so you can just go through it post commencement of this completion of this conference. Further, we would like to thank all our esteemed panelists and guest speakers for today. Each with their unique expertise and experiences has added a lot of knowledge and value to our event. We look forward to the valuable insights further in future. We would also like to express our sincere gratitude to all the speakers for their valuable contribution throughout the conference. Your expertise and knowledge have undoubtedly enriched our understanding of the subject matter. Looking ahead, we are excited to announce that our next conference will be held in November from 15 to 17 on the topic of effective marketing strategies for startups from launch to growth. We hope to see you all there and engage in those insightful discussions. Thank you, and we look forward to reconnecting with you in our upcoming conference on November 15th. Further, we would also like to inform all the participants that the certificate form link will be soon shared in all the conference groups. So you may kindly go through it and fill it to avail your certification. The certificate of honor for all the guest speakers shall be mailed by the HR team by tonight itself. Thank you, everyone. Have a great day, and obviously keep dreaming and keep starting.